So Jim, Adam, take it away.
Well, I'll start off. I guess I want to thank everybody for attending today. My name is Jim Singer. I'm from the St. Louis law firm of Schuchat, Cook and Werner. I have spent the vast majority of my career as a union labor lawyer, practicing general labor law and employee benefits law. I've counseled labor unions in countless situations involving drug testing programs, and find these recent developments to raise very difficult issues for both unions, their members, and employers. And I want to thank my co-presenter, Adam Dorr, for putting together this PowerPoint. Adam did a very, very nice job. Adam?
Thanks, Jim. Yeah, we'll see if everybody agrees at the end, but I appreciate that plug. My name's Adam Dorr. I work out of the St. Louis office of Jackson Lewis, national management side labor and employment law firm. Yeah, this seems to have taken a bit of a back seat in terms of topics based on where we were maybe a year or so ago, but it actually is extremely timely. Because medical marijuana sales are on the verge of coming to sale here, which we'll talk more about. But I think this is a very timely presentation and discussion to have. And I very much look forward to having that conversation with my co-presenter, Jim, and all of you. So I guess if we can get the PowerPoint started, we'll get going. Who do we have running that PowerPoint?
Doug, are you running the PowerPoint? We see there you go.
There you go.
Sorry,
So
I was
we're-
putting somebody in the last minute.
No, you're fine. So Jim and I are going to talk a little bit about what the Missouri and Illinois marijuana laws say, just to kind of provide that foundational context, and then we'll talk more about the labor law, employment law implications and considerations, and we'll share some horror stories of our own maybe, and pass along some best practices along the way. But of course, as we said, please feel free to chime in with a chat or raise your hand or whatever you got to do to get our attention if you want to ask a question or make a comment. We're happy to address that on the fly. We already did our intro, so you can probably breeze over slide 3. There's us. And this I just wanted to show as a, based on where we were 10 years ago, 20 years ago, you name how long ago, this is just how prevalent the patchwork of marijuana laws is in America right now. So you can't operate in 2 different states without having to consider 2 different marijuana laws specifically, while understanding it's still illegal under federal law. So there's a lot to juggle here, and it's rapidly evolving. So that's just kind of the point of this graphic here. But it seems, I don't know if Jim agrees, but it seems inevitable to me that it's going to fall off the federal radar. There's got to be at some point there's a tipping point where you just can't ignore what 30 some states and territories have done. Jim, do you agree, or is this just going to linger forever?
Well, I don't know when the federal government's going to come to grips with it. It's obviously, is shown by the Missouri experience, it's got the popular support. So even in a relatively conservative state like Missouri, same with Oklahoma, Arkansas. So, it isn't a red state, blue state thing. So I don't know. It's very difficult to predict these kind of things.
Maybe it's just a government inaction thing. It's tough to do anything, right? I mean, there's some truth to that, maybe. Okay. And the next slide is something of a word cloud of what maybe some people, just if you think what comes to mind when you're talking about marijuana in the workplace. And I'm curious if people want to drop in some chats or chime in with some unmute and give us a couple words. What comes to your mind when we're talking about this? Is it scary and risky to you, or is it something that's kind of a non-issue and it's just a matter of administration? Or a lot of my clients are concerned about, most importantly, safety sensitive positions. And secondly, just making sure that they aren't violating either state or federal law in administering their policies. Is that a similar scope of concerns you're seeing, Jim?
Well, we don't advise employers. So, I mean, we really see it more from the member union standpoint. In thinking about this slide, I came up with two scenarios, which I thought the audience might want to think about as we go through the other slides. So the first scenario is that you have a member or an employee, in the case of the employer, who buys CBD oil. And as we'll see, it's completely lawful in all states, federal and state law. There's no legality issues. So, it wouldn't be surprising if your members or your employees are buying CBD oil for various reasons, such as relieving chronic pain, arthritis, etc. The second scenario is that now in Missouri, we have the medical marijuana. It's completely lawful for employees and members to get a marijuana card for medical purposes. And the Post-Dispatch has an article this morning, it's very timely, that the dispensaries are just about ready to go. There's one out in the St. Louis County that's just waiting for the product. But here in the St. Louis area, it's a very simple thing to drive across the Mississippi River over to Illinois and buy marijuana lawfully for any purpose, as long as I think you're age 21. So, you can have a member, he's got the medical marijuana card, goes over to Illinois, buys pot, comes back over here. And so they're at work, there's a random drug test, he has an accident, all of a sudden he's drug tested. Though that is, to me, from the member union standpoint, the problem areas or the sort of typical scenarios that I'd like you to be thinking about as we go through these other slides.
Yeah, that's great. Then, I think these days, I think more and more people are cognizant of the imperfections in the testing and all those things, which just makes it all the more difficult, I think, to straddle the line of making sure you're keeping everybody safe while administering fair policies without encroaching on people's rights to do as they wish. So those are great scenarios, and I hope everybody keeps those iterations in mind as we go through this, because it's extremely complicated, and I hope that we'll touch on a lot of those issues. So here's an overview snapshots, just comparing the Missouri and Illinois marijuana laws. Of course, we've only got medical marijuana in Missouri, coming soon at least, and medical and recreational adult use in Illinois. So aside from that, the difference is the details we have to work with. The Missouri amendment is a 13-page sign here. We passed as Missourians. Illinois sat down as a legislature, I think the first state to do so, and hammered out a 600-something page statutory framework for all of this. So for better or for worse, we've got more to work with as lawyers in Illinois, and maybe less in Missouri.
So I have a question there, Adam. You say it from a lawyer's perspective, you have more to work with in Illinois than in Missouri. From a workplace perspective, is that better or worse?
Well, we'll look at what the law says. I mean, just because we have more, it doesn't necessarily make it easier or better or worse. It just creates different areas of gray, different shades of gray, different uncertainties. The big one in Illinois is going to be, what does it mean to have a reasonable policy? And we can skip through some of these slides and kind of get there. But in Missouri, we've got nothing. We've got pretty much nothing except, and here's what Missouri says. It allows qualifying medical conditions to permit people to use medical marijuana. It's pretty simple. It has a list of does nots. It does not allow people to operate machinery or do anything dangerous while under the influence. But to me, and Jim, I'm curious to hear how you read this. When I see a law says it does not allow this, to me that still leaves every other iteration unaddressed. It's a single carve out, but it's not a comprehensive, but everything else is okay or everything else is not okay. So it's very, yeah, go ahead.
What I was going to say is this, that in the labor management context, which I think is sort of this, we're not really dealing with the non-union world. These disputes, if they can't get resolved disputes between labor and management get submitted through the grievance arbitration procedure. So if they don't get resolved at the grievance procedure, then they go to arbitration. There is this body of law, or I should say arbitral principles, that arbitrators are supposed to look to the labor agreement and not to outside law. And many arbitrators are not, probably most arbitrators are not lawyers. So they don't feel particularly comfortable looking at the law. And so there is this question, other than background, what is, if you get into arbitration, what is the relevance that Illinois says this and Missouri says that? I throw that out as a question. Obviously it's important background. The second thing that I've noticed is that, the only way arbitration decisions become available to unions and employers is if they get published and picked up by the major reporting services. Many parties don't want their decisions published. I mean, I would probably say it's the exception when a decision gets published, particularly in an area like this where there's an element of privacy or an embarrassment or whatever, where either the employer or the union wouldn't want it published. You've got to have the consent of both sides. And from what I can tell, I haven't done exhaustive research on this, but from what I've seen, there, in spite of these recent legal developments with marijuana, there is I haven't seen any published decisions where arbitrators have really come to grips with the new environment that we're living under. So we're still sort of in uncharted water, which, makes it interesting. As I tell clients, well, this is really interesting, which isn't good for clients. Lawyers love interesting problems, but, clients want to know what's the answer. And there hasn't been a whole lot of guidance coming out from these published arbitration decisions, which aren't binding. They're simply used as arbitrators like to cite prior decisions. So I'm done.
Jim, you just saw that article in the paper this morning. You want to tell us more about where the process is in Missouri?
Well, we're, according to the Post-Dispatch, we're on the verge of the Missouri dispensaries dispensing marijuana in different forms, gummies, chocolates, the marijuana to smoke, etc., is going to be available shortly. They don't have the product. I don't quite understand what the problem is getting the product, but the Post said that it's anytime soon we're going to have the dispensaries open in the St. Louis area.
I believe one of the nuances of Missouri Amendment 2 was that the marijuana consumed in Missouri has to be grown in Missouri. And so first the producers had to get certified, they had to probably get the rules on how to certify the producers. Then the producers had to, get their infrastructure in place, grow the product. And so it created a different timeline than in other states where, they could import, marijuana that was grown across the border.
Yeah, I was Jim and I were just chatting in preparing for this, and I thought I suggested to him that I thought that despite it not yet being available, because the law is still in effect and medical marijuana cards are available, it's possible to lawfully possess marijuana in Missouri without having lawfully bought it. So it's possible that, although it's obvious that they just ran across the river to Collinsville and came back, they've now got a card that protects their possession of marijuana. I don't know how far back they could reach to say, oh, but the poisonous tree, it came from a illegal source. I don't know that. I haven't seen any cases or decisions on that.
And with a card, you could have grown your own in Missouri.
Right. Perhaps that's why there's really no way to, enforce that, so to speak. But it is an interesting state of affairs. And, Jim, you mentioned the availability of gummies and other means of ingestion. To me, that is one of the scariest parts about when I'm trying to advise employers how to safely enforce, drug-free workplaces and safety-sensitive positions. You can't tell if somebody's having a cookie with lunch or if they're having an actual lunch marijuana hit. It is almost that innocuous and difficult. And I think that's, until we have better testing, that's going to be the thorn in all of our sides, is on the employer side.
So let's say just on that slide, real quick, we had the links to the Missouri forms that are currently in use. I mean, this is not something that is out there in the distant future. I mean, people for the last year or so, have been able to apply for their cards. The physicians have a form to use, which is available to the public. I mean, not the blank form. And then they get their cards. So people have the cards. I think we're ready for the next one.
Yep, so this is kind of a similar slide that we had for Missouri, but focusing on Illinois. Like I said, you've got 600 pages of statutory text to work from. So to me, the big takeaway is Illinois focuses on, yes, you can enforce and have zero tolerance policies, but they still must be reasonable and, of course, non-discriminatory. Reasonable is not defined in the statute, though we can look at case law and kind of guess as to what that means. I think, and I really look forward to Jim's input on this point, I think that Illinois law does protect collectively bargained policies.
Well, that's interesting. Well, in really,
I didn't mean to put you on the spot like that.
I mean, I don't know what if you're asking an arbitrator to determine if the policy is reasonable and was it properly applied in an arbitration over in Illinois. I'm not sure that the Illinois law is that material, other again as background, because I think this is really important to keep in mind in the labor management relations. Generally speaking, the overriding issue in any discipline, including drug testing, is going to be the so-called just cause standard or the cause standard. And those one or two little words have so many permutations in terms of what is expected to meet that standard. I mean, the employees are no longer employees at will. And so under the just cause standard, if the union has not agreed to the drug testing, and and we're going to be getting into bargaining issues shortly, then the policy can be attacked both as not being reasonable, and then it can also be that it wasn't, that the application didn't meet the just cause standard. I just, in your typical arbitration, I'm not sure that this external law is going to be that important.
Yeah, I think that that's right. And I just saw a decision recently where a CBA specified that an odor of marijuana paired with a positive test was going to constitute just cause. And so be it. The arbitrator found that there was testimony as to the strong odor and there was evidence of a positive test bound by the contract. The arbitrator ruled there was just cause. Where there could be other concern, though, is if in the course of an existing CBA, this law comes into effect that says, by the way, a policy must be reasonable. Now, you might open yourself up to arguments that this existing policy we had is no longer enforceable or reasonable, or in an employment non-labor context, a wrongful discharge or what have you. So I think that, at least from an arbitration standpoint, I trust that mutually bargained and agreed to policies will be applied. I think you're right. I think there are other issues if you start looking at wrongful discharge litigation, certainly outside the arbitration process, but that's a good point. So this is what I was talking about in terms of just having some guidance about what reasonable might mean in Illinois. It's kind of in the similar context, except it's now 6 years old. So I don't know if that makes it stale or not. But generally, the policy is going to have to be connected to the employee's job performance, some kind of nexus. And at least in this case, the court suggested that in safety-sensitive positions, signs of impairment wouldn't be necessary before justifying a termination. Now, this isn't in a labor arbitration context, but just in terms of employers looking for some hope that they can still err on the side of safety without opening themselves up to this kind of discharge litigation. This is where I get some comfort, even though I would still caution, be careful in any discipline based on a drug test without more. Jim?
Well, here we get into the bargaining issues. The first question, which is certainly not unique to drug testing, is whether a labor union employer want to have an agreed upon drug testing program. And I think Adam raised a good point. Once it's in the contract, that's the rule that the parties are going to be required to follow, and the grievance procedure will be imposed upon them by an arbitrator. So there's this, there's pluses and minuses from the union standpoint to have an agreed upon policy. The pluses are that in order to get an agreement, you may be able to get protections for the members that wouldn't be otherwise available. The minus is that once it's agreed upon, you can't attack it. You can't say this is unreasonable. It's really the remaining question is, did the employer apply the agreed upon policy? So if the employer is saying, look, I've got to have provisions in this drug testing policy that the union finds is just, we can't agree to that, then many times unions will not, there won't be an agreed upon policy. Or many times the employers will say, we make the work rules. We want to change the policy during the term of the contract. You can attack it under the just cause standard. But when the labor agreement's up, drug testing is certainly a mandatory subject of bargaining. One of the issues here is certainly important, especially with this scenario, to think to be aware of the drug testing these developments with marijuana. And I think even before you get into bargaining, it would be a service to your members to say, look, I'm not passing judgment on any of you, but if you're, buying the CBD oil or you got your marijuana card and you're growing your own, you're going over to Illinois, have you thought through what happens if there's a random drug test or if you have an accident and they can test you because of the accident? And on our list here is the CBD oil. There's a tremendous amount of misunderstanding about CBD oil. And there's a lot of misinformation or fake news, that's on the internet. There's a really good article that Consumer Reports did in May of 2019, and we included a link at the end of the PowerPoint. And the article is titled, "Can You Take CBD and Pass a Drug Test?" I think a lot of people think the answer is yes, but as the article points out, and they quote all these experts in pharmacology, that for a couple of reasons, the answer may be no. It's really for two basic reasons. The first is that CBD oil is completely unregulated. You can't, there's all sorts of puffery, or whatever you want to call it, that you can't rely upon. There's no, it's not like the FDA has certified the amount of THC in CBD oil. So you don't really know what it is that what is the amount of THC in the CBD oil product that you're taking, in spite of what may be on the bottle. The second thing is that because of the, I guess, internal chemistry that the THC accumulates in your body fat, and even if you take small amounts regularly, which is frequently how people take CBD oil, it can accumulate and then cause a positive test for marijuana. So, if you can educate the members a little bit, maybe they want to change their behavior, at least they know the risk that they're taking. Another bargaining issue that we put on here is employee assistance programs. From the union member standpoint, the member wants the opportunity to go through the program after a positive test. One could say, well, that's, if you assume that taking CBD oil or smoking or taking marijuana is a problem, then that's what the EAP program is for. But some of these EAP, and so you would want, from the union standpoint, that if an employee tests positive, they then have access to the EAP prior to discipline, and that becomes the first recourse, so to speak, for a positive test. And there are drug testing policies that provide that, no, you have to go to EAP on your own. And if you test positive, then you don't have access to EAP. So that's really important thing to look at to think about when you're bargaining over a drug testing program. Another item on the list, and we get into this in some other slides, is what triggers discipline under a drug testing program. You'll see in these slides that impairment and under the influence are two terms that are used by arbitrators and in drug testing programs. You'll see them in labor agreements sometimes. And what do those mean? And is it necessary for an employer to show impairment or under the influence? I mean, if there's one big issue, particularly with marijuana, it is that and we'll see this, there really are not any cost-effective tests that can determine impairment or under the influence. There is no cost-effective blood test for marijuana. And that's really what's needed to determine if someone's impaired or under the influence. That's what is used for alcohol. And this is not an issue that's limited to the employment setting. It's really, in some ways, much more critical in law enforcement. You know, how are the police to know or prove that someone is impaired or under the influence if they pull over a driver, other than by observing them? Because the blood tests, I saw a figure a year ago, they cost in the thousands of dollars. It's just not practical. So that's another question. Is your drug testing policy going to be triggered where it's simply a positive test and there's no evidence of impairment or under the influence? So those are the bargaining issues, Adam, that I wanted to review. I don't know if you have any others that you want to touch on or talk about.
Yeah, I just think that raises a lot of interesting questions. And I think, to me, a lot of it comes down to how the parties are able to agree. Hopefully they're able to, and how they're able to spell out their drug testing program with, precisely, as Jim alluded to, what leads to discipline. We can all agree that people, electricians and other steel workers maybe shouldn't be high on the job. I think we can all agree, but what does that look like in practice in terms of enforcement and administering that policy? It's a struggle, and I think the more that the parties can agree up front in a CBA, and if it has to be over inclusive, we're going to random test, and a positive test, you're out. If that's what the parties agree has to be done, so be it. But of course, I think the best approach is taking a close look at the specific work, the specific positions involved, and consider to what extent it's a problem. It might be a problem, the seriousness, the gravity of the problem, and the most appropriate way to balance all those competing considerations. If a lot of jobs really just don't have the same risk. But I'm sorry, if you're a steel worker, working up, 6-10 stories up, or operating, high voltage electrical wires, I want to be safe first, and then worry about the CBD oil second. But it's a really tough balancing that I think needs to be done almost at the job or position level, to avoid having a one-size-fits-all approach, which I just don't think is appropriate in most contexts. But hammering those issues out in bargaining, I think, saves a lot of headaches down the road.
Well, okay, if we could go back to the prior slide, because we were talking about bargaining issues. So this slide talks about, okay, you've got the agreed upon drug testing program, or you've got the employer imposed program the union didn't agree to. And now we have discipline, which is subject to the grievance procedure. One of the things that if there's one thing I could impress upon labor unions and union members is that the most critical moment in this whole process of discipline, grievance, arbitration is when the member is confronted by the employer. So, your typical scenario again is random drug tests. Maybe it's completely random. Maybe there's been an accident. Maybe the employee's coming back from a leave of absence. One of these events triggers a drug test. And the employee has tested positive. And they're called in by the employer and confronted with this. Now, under federal labor law, the employee has the right to have the steward there. And many times it's the business representative. What is the union to advise the employee? Because it's understandable that the employee is almost like a deer in the headlights. They're starting to think, what did I do? Here, well, CBD oil, it's lawful. I can't be in trouble for that. Medical marijuana, I went to my doctor. I've got my card. There's maybe a dispensary right here in St. Louis that I bought it from. I grew my own. I went over to Illinois. Everything was lawful. Why am I in trouble? The employer at that meeting typically will want to hear the employee's side of it. Now, what is the union what would the union tell the employee? Well, to me, the most important thing to tell the employee is, if you're going to say anything, it better be true. Don't lie. It's kind of like being caught cheating on your spouse. The first impulse is lie. Well, don't lie. It's better to say nothing than to lie. Because the problem is that as you get further into the process and more documentation comes out, now, okay, well, you didn't tell the truth. And it really creates an additional problem in terms of trying to get the employee back to work. Because, the employer will always be able to say, well, you had an obligation to tell us the truth in our investigation. And another point is, it's not just the confrontation with HR or the supervisor, but when you're drug tested, part of the process is that there is a medical review officer who is this key individual in the drug testing policy, who's supposed to, the employee will get a form saying, if you have any questions about the positive test, please call the medical review officer. Well, to an uninformed person, and maybe to a lot of informed people, you'd think, oh, there's a doctor that is this medical expert that I can go to and confide in. That's the medical review officer. Well, that is just not the case. The medical review officer is typically a business. Now, there is a physician who oversees the business, but the business, the contact with the employees, by and large, is with nurses of different educational levels, and the employee calls the medical review officer. All the conversations are recorded. There's a standard introduction. It's a recorded conversation. The employee talks to somebody different every time they call, and if you get into a dispute over it, these recorded conversations are all going to be available to the employer. So again, if it adds more grist to the mill if you don't have a truthful, straightforward account of what took place. So that to me is the upfront most important thing the union could advise the member at the beginning of the disciplinary process. These other items that we put here, let's see, the second box in terms of impairment and under the influence, that's really going to be a big problem, could be a big problem for the employer. How do you prove that an employee was under the influence or was impaired? That would typically be a foreman or somebody like that who has observed unusual behavior. Proper enforcement of the policy, part of the just cause standard is that employers are expected to follow their policies. So you would certainly want to read the policy carefully and see if it was followed. I mean, if I think a lot of employers don't put a lot of thought into these drug testing policies. They get it from maybe they get it on the internet. They haven't been carefully thought out many times. And so, read the policy and see if the employer has followed its own policy. Another part of the just cause standard is disparate treatment. Are you treating people who commit the same offense the same? So, if you're a good worker and you come back from a leave of absence, does the employer not drug test you? But if you've been in trouble, they do drug test you. And, that'd be classic disparate treatment. Or if you test positive, the good worker goes to EAP, but if you're trouble, you're going to be terminated without the opportunity to go to EAP. That'd be classic disparate treatment that would trigger the just cause standard. Other evidence, observations of impairment, I think we touched on. So I pass it over to Adam.
Yeah, I think that was excellent. If I just want to highlight one thing that you said, it's I would absolutely emphasize the honesty aspect. I've seen a lot more arbitrators overturn discharges for marijuana offenses than I have for dishonesty offenses. So as soon as you have lied during the investigation, you've just made Jim's job a whole lot harder and mine a whole lot easier. There was one arbitration that a guy was seen on the way to a drug test tossing away a vial of some other substance, which turned out to be an attempt to cheat the test, but he was caught red-handed in that attempt. But his test came back negative. The real test came back negative, but he was terminated for the dishonest attempt to cheat the test. So I think the tide of the times and of courts and of arbitrators are shifting towards leniency for CBD or medical marijuana or even recreational responsible use. I'm seeing a whole lot more leniency on that than I am on dishonesty. So I think Jim's right to emphasize that. I don't think he's just trying to throw the members under the bus there or anything. That is a critical aspect to saving your job.
The next slide, Adam. Okay. This is I highly recommend, sort of an aside to both labor unions and employers for that matter, this book, Discipline, Discharge, and Arbitration. There's a whole chapter on drug testing, which and it's all about discipline and discharge, not really a bargaining book. So anyway, it's a great resource. And the quote here is really this fundamental point that a urine test, which is the typical test for marijuana, does not it's not a finding of that you're under the influence or impaired. And so there's this disconnect that's really fundamental If the interest of the employer is to avoid someone being at work under the influence or impaired, which certainly is legitimate, very legitimate. I mean, the employer is responsible for maintaining a safe workplace. They're using a test which doesn't accomplish the goal, and they're really and they're kind of stuck because there is no practical substitute for it currently, which would be the equivalent of a blood test. So it's important for you to understand that.
Yeah, I would just add that it's all the more important that in a collective bargaining context, the parties are clear about what the policy covers. If it describes impairment, describe what that means. If it refers to being under the influence, describe what that means. And if it just refers to positive tests, so be it. But do be very cognizant that a positive test does not establish or prove impairments or under the influence. And I think this next slide is going to highlight that even more.
Well, the next slide is another quote from the Discipline and Discharge book. And it's again, I guess really the same fundamental point that the urine test doesn't doesn't prove impairment, that the presence of metabolites, the THC metabolites in urine can be there long after an employee smoked marijuana or ate a gummy bear, and there's no impairment. So that's really important for you to understand that, and I think Adam's done a good job of pointing this out, that an employer could draft the drug testing policy that, and certainly if the union agreed to it, that basically would have this underlying assumption, because there's no effective test for impairment, that if you trigger the metabolite level of a drug test, you flunk the test. And if the unions agreed to that, then you're kind of stuck. You can't say, well, what about impairment? And well, what does the drug testing policy say? Now, if it's an imposed drug testing policy, then you can make the argument, well, you haven't improved any impact at the workplace. So typically, what an employer will do is if you get in an arbitration in the grievance procedure, they'll say, okay, you flunked the drug test, and we've got this other evidence. You were stumbling around. You smelled like pot. That's typically how it would be done. Adam, anything else?
Yeah, that's right. To the extent it might be of any help to anybody looking for, okay, well, how do I establish impairments under the influence? The Illinois statute does provide a list of 10 or so factors that can be relied upon as evidence of impairment. Now, I mean, we've said before that outside statutory law doesn't just get embedded into contracts, but that's at least a starting point to look to, or even to bargain over. What can I, as an employer, as a manager, rely on to demonstrate impairments or being under the influence, aside from a drug test and odor, having on you, possession, maybe stumbling, things like that. But that's so much of that is subjective and going to be challenged probably anyway. I think we're going to be best off just being as clear and open we can during the bargaining process and agreeing to what is and is not going to be a discipline offense. This kind of sums up. Yeah. I mean, I think we both have probably a handful of recommendations for everybody. I think communication is the number one, in my book, the number one important recommendation in any labor management context. If most of the time you're talking about mandatory subjects or subjects covered by the contract, so you better make sure you're on the same page anyway. Training, I think, and being flexible without being inconsistent are also critical. And there's no easy way in this particular environment to train on impairment or being under the influence. It's just a lot of trying and good faith efforts in communication, and be very cognizant of the specific context. If it's a safety sensitive position, I am going to suggest erring on the side of safety. But absent that, I'm going to err on the side of avoid having to call your lawyer. Jim, what do you think?
Well, on the communication, the two things I'd want to emphasize is first, from the union standpoint, when you have the opportunity, it'd probably be helpful to communicate to your members that if there is a drug testing policy, they need to be aware of it, and they need to think through if what they're doing now in Missouri or Illinois is going to create a problem for them. The union can't do magic if they're violating the explicit terms of the policy. So they're adults. They will make decisions, but I think it's important for them to be aware of this, and the employer would have the same interest. You'd think. And then the second thing is to communicate with the employer. I mean, to really have a frank conversation across the bargaining table, whether it's in contract negotiations or in the midterm of the contract. Until the pandemic, we had this shortage of good skilled workers. And I suspect, or I hope, I should say, that it will return to that soon. And even with the pandemic, I think it's hard to get good workers who are skilled to work at many jobs that may have risks because of the pandemic. And so does an employer really want to put in its policy that they're going to get rid of employees who are not impaired or are not under the influence? Because once you can't, or I should say, it's a problem under the just cause standard to have a rule. You may be fired if you test positive for marijuana. And then you don't fire Joe, but you fire Charlie. Why did you distinguish between these two people? Well, Joe's a good guy and Charlie's not a good guy. You've backed yourself into some pretty serious potential problems, whether it's under the just cause standard or whether somebody says, well, I was African American, or I was a woman, or I was this, or I was that, and you were discriminating against me for some unlawful reason. So very important issues to think through with these new developments across the bargaining table. On training the supervisors, from what I've seen, there's very little of that going on. Now, obviously, it depends on the employer and the specific workplace. But the supervisors are as much in the dark about how all these developments with marijuana impact a drug testing program as the members are. And maybe it's because the employers don't know what to tell them. That these problems that we've that we've been focused on, the employers, don't have an answer, so therefore they don't tell their, it's just this gray area that they don't want to clarify, which I don't think is a good idea. And remain flexible. Well, I certainly agree with the first bullet point, but not be flip-floppy, which is not treat apply the rule uniformly. And it's an evolving area. It is, but to some extent, it's evolved. we're at in Missouri and Illinois. I guess Missouri may at some point go to recreational, but just accept the law, accept the situation right now as it is, and figure out what makes sense at the workplace and with people. A majority of the citizens of the state of Missouri voted, I think, pretty overwhelmingly for medical marijuana. And, does it make sense now to continue to have a drug testing policy that says you're going to be terminated if you test positive for marijuana? So that's all I have on that.
Yeah,
Since we're kind of running out of time, Adam, should we?
Yeah. And I see some questions maybe coming in. So for the last couple minutes, let's just see what we have. There's the additional resources Jim was talking about. There's a report that was put out by the University of Missouri, as well as the article from the Consumer Reports. There's one question, Jim, I see in the chat box about aside from federally mandated testing, are employers taking marijuana out of the drug testing panel altogether? And I'd say some are, at least for some contexts, but wholesale, I'm not seeing that.
Yeah, I haven't seen it either.
But go ahead. I mean, I'm just going to say in terms, there's going to be certain contexts where employers are going to insist on some kind of marijuana testing, especially if there's a safety sensitive component to the job.
Go ahead, Ann.
I was going to say, but I will suggest to employers whose positions that they're considering aren't safety sensitive at all, then there's no need for it at all. I mean, honestly, at that point, it's just a matter of job performance and coherence at work, just like you treat alcohol.
So, and have you seen employers be open to saying to the workforce, if you're going to if you're going to use medical marijuana in Missouri, you need to tell us that, and then you've got to understand you can't that. We may keep an eye on whether you're showing up impaired or under the influence. I mean, has there been some recognition or CBD oil, that, okay, you can do this, but you can't show up to work, stoned?
Yes. It's tough. I do think that employers are grappling with that. I'm seeing this other question now about other testing, which
there's a saliva test. Is that
there's all that? Yeah, and I don't know about the saliva test in terms of, if it's only detectable for 24 hours. I still don't know if that gets you to proving impairment, because it could have been a nominal amount that really has no impact on your physical functioning, or it could be, an entire brownie. I don't know. But, I haven't seen anybody moving to saliva tests as the solution.
I'd like to encourage participants to, if you have questions, you can unmute your microphone and ask the questions. This has been a wonderful presentation, by the way, gentlemen. A question I have for you is, and I haven't looked in about a year, but last year I was trying to look at the states that have already deregulated or legalized marijuana use to see if there had been any changes in employment law or employment practices. If there's a bright line in other states, and by and large, a year ago when I looked, other states were kind of taking a real laissez-faire approach towards it. And they were mostly the ones that I talked with, said, we're treating it like alcohol. did you look at other states to see if they're, like the early adopters like Colorado or Oregon or California, to see if there's been a spike in how they've addressed the issue of impairment?
I've seen a number of states, like state highway patrols, departments of transportation, police, law enforcement agencies impose something of a THC limit, whether be it by breath or blood or some other means. But that's just, an arbitrary number as far as I know. It's, I guess, better than nothing, but not scientifically demonstrative. I guess, just to go back 1 minute to Jim's question about, employers wanting employees to kind of self-disclose up front. To me, I see that more in the ADA context. In Missouri, your use is medical, so that flags to me, there's a medical issue. So if you need to be accommodated, including maybe by leniency on a drug test, as long as it's not a safety sensitive condition, perhaps, that might be something employers would consider. But otherwise, I don't think employers require upfront disclosure of all medications, whether it's marijuana or something else. It's on the employee to disclose it if they have a medical reason for it, but I don't see it mandatory required all the time.
You want, and I haven't seen this come up, but you would, and I'm sure some of these medical marijuana exams maybe aren't the most careful exams. I don't mean to demean the medical profession, but you'd think that a physician in issuing a medical marijuana card would tell the individual, okay, don't operate a motor vehicle, don't show up to work under the influence, and that I don't know where I'm heading with all this. That is there, I guess I pose as a question, is there a way of accommodating the use of medical marijuana with the workplace?
I think so. I think the problem is if there's a safety sensitive component, right? Then I think there's going to have to be some pushback.
And if the, if the individual says, well, I was off work on vacation, and or I take the CBD oil and it doesn't impact anything, or if I'm not showing up to work impaired because I'm careful about it, am I going to get in trouble?
Maybe.
Or if you, let's say we got a long-term employee, 10-year employee, good track record, good employee, comes in with a medical card, but they're in a safety sensitive position. Does that mean the employer under ADA, or does the employer have to accommodate them by finding a position that's not safety sensitive for them? Or is the recourse for the employer to say, sorry, you're no longer qualified for this position?
And I'm wondering is if the employer, whether it's safety sensitive or the employer just doesn't want to, wants to have a simple rule, black letter rule, you flunk the marijuana test, you're going to be terminated. That shouldn't the employer be saying to its workforce, I know there's, I understand all this stuff, you can drive down the street and see all this CBD advertised, all the stores. You may have your medical marijuana card, but if we have random testing here, if you get in an accident, you come back from leave of absence, it won't matter under our drug testing policy. I mean, I don't see employers doing that.
I think everybody ought to be crystal clear. I think you and I might be out of work if we're too careful and speaking too openly. But that's the point. I think we have to be communication both ways. so that there aren't any surprises in what the policy means and how it's going to be enforced. I mean, litigation is because somebody's upset about something. They feel unfair, treated unfairly. But if we're upfront and on the same page from day one, then you've got no one to blame but yourself.
So here we have another comment, another chat. Went away. Let me see.
Yeah. Is medical
You-
marijuana a reasonable accommodation despite being illegal under federal law? The answer is no. Like if you've got a disability that you're requesting an accommodation from an employer for to help you do your job, the employer doesn't have to say, oh, here's some medical marijuana. I hope it helps you do your job. That's what a reasonable accommodation means. But if you suffer from a disability and have a prescription for marijuana, a reasonable accommodation might be leniency in being allowed to fail the marijuana component of the drug test. And that can be a reasonable accommodation, even though it's illegal under federal law. The federal courts are definitely kind of parting from the it's illegal, so everything related to it's illegal. They're kind of allowing states to implement their programs. Jim, is that what you're seeing? Or,
I defer to you on that.
yeah, it's pretty remarkable. The Supreme Court just 10 or 20 years ago said, no, we can completely outlaw it and come in and raid California's dispensaries. But since then, district courts pretty routinely uphold states' programs. I think because the federal law deals with the criminal prosecution of it, but they've taken the position that they don't govern employment or otherwise dabble in that realm of it. That's how they've justified it that I've seen. Great questions, great discussion. Any other questions or thoughts, Jim?
No, I think we're out of time.
I think we're out of time too.
Outstanding presentation, gentlemen. Thank you very much. Once again, I find that the most engaging conversations is when we have advocates, from traditional opposite viewpoints getting together, and we find that you agree on so much and this has made for a wonderful presentation, though. Thank you very much. Is it okay if we share your slideshow with participants?
Is okay.
Your contact information's in there. There's some good resources in there, so we'll send that out to participants. And again, thank